Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to look at a case that is fundamental for firearm prohibition hearings as well as Section 74 firearm reviews. So this is one of those cases that if you are interested in this area, you really have to know, particularly because the Supreme Court doesn't often wade into that area, and they have in this particular case. This is the case of the Queen and Zeolkowski, which is a 1989 decision. That said, although it's a little dated at this point, it's still good law. Nothing has overturned this, and Supreme Court, the Supreme Court kind of runs the show. So this is a really big deal. So the background on this one starts out with the hearing in the provincial court level, which arose out of an incident on January 28, 1985. The sergeant of the Winnipeg Police Department made an application pursuant to Section 98 sub 4 of the Criminal Code, as it then was. The parallel section now is now Section 111 of the Criminal Code. But they've basically done some editing and some alteration, which happens over time with the Criminal Code, for an order prohibiting the respondent from possessing any firearms or ammunition or explosive substances. The respondent's wife had informed the officer that the respondent had threatened her and that she believed that the respondent, that's Mr. Zeolkowski, would use the weapons against her. So that's why they want to ban this guy from having guns, is that they say he's threatened his wife. So the hearing of the application commenced on May 17, 1985. Prior to the calling of any evidence, counsel for the respondent, again, that's Mr. Zeolkowski, who they're trying to ban from having guns and who does not want to be banned from having guns, requested a ruling on the nature of the evidence which the court would permit during the hearing. In particular, counsel sought a general ruling to prohibit witnesses from testifying as to facts based on hearsay information. This request was prompted by the Crown's intention to call the sergeant to testify as to what the respondent's wife had told him, rather than calling the wife herself to testify, and the custom in Manitoba provincial courts of permitting hearsay testimony at hearings on applications for a firearm prohibition. So why the respondent wants this is they don't have the wife there. She's not around. Maybe she doesn't want to testify. Maybe she's decided, she's not participating in this. But they want the sergeant to be able to testify as to what she said. That would ordinarily be, pretty textbook hearsay. So he wants that evidence out because once that evidence is out, the Crown's going to have a real tough battle, as we'll see in a moment here. So after considering the written arguments submitted by both counsel, the trial judge ruled that hearsay evidence was inadmissible, in that evidence at a hearing under the section is limited to that which would be admissible at a criminal trial. When the hearing recommenced, the Crown called no evidence because their evidence has just been determined to be inadmissible. They don't have anything else at this point. They got to pack up their bags and leave. And the trial judge dismissed the application, which of course they'd have to once there's no evidence being called. On appeal by the Crown to the Court of Queen's Bench, the justice held that the trial judge had made the correct ruling on admissibility. But the Crown doesn't stop there. They go up to the Court of Appeal. On further appeal, the majority of the Court of Appeal concluded that the ordinary rules of evidence should not be relaxed. Notwithstanding that the respondent was not faced with a criminal charge or punishment, his rights might be affected by a firearm prohibition order. They certainly would be affected because now he's got certain restrictions on his behavior that would prevent him from doing things he might otherwise be able to do, with criminal sanctions potentially resulting if he steps over that line. So absent a clear direction to the contrary, the general rules of evidence apply in a judicial proceeding. The majority was of the view that the term all relevant evidence does not invite the conclusion that Parliament intended the rules of evidence to be relaxed or varied in a hearing under Section 98 sub 6, which was again, the section at the time. Now, the language here is, this is what the rules are, but they're just describing the Court of Appeal's decision. This is not the Supreme Court's conclusion at this stage. So one justice dissented. And this was, in fact, the Chief Justice, although that doesn't mean a whole lot in terms of, the weight of their takes here. So the Chief Justice was of the view that the proceedings constitutes gun control legislation, which is designed to minimize the risks and dangers resulting from the free and uncontrolled use of firearms. In his opinion, the only requirement in these proceedings is that the evidence be relevant to the issue to be determined. Thus, hearsay evidence is admissible. And he approved the reasoning of a Nova Scotia decision, which was the Queen and McWhirter. All right, so the key bit of language here is, at the hearing of an application pursuant to the section, the provincial court judge shall hear all relevant evidence presented on behalf of the applicant and the person against whom the order of prohibition is sought. All relevant evidence. That's the key language, and that shows up in several places in both the Criminal Code and in the Firearms Act. So that this is essentially the phrase that the Supreme Court is being asked to interpret and to tell us what it means. All right, so this is the same sort of procedure at the time that is used for when you apply for a firearms acquisition certificate. However, again, the law has since changed, but that phrase of all relevant evidence also appears in the new Section 74 of the Firearms Act, or sorry, not Section 74, but the related provisions. So I use Section 74 sometimes a little colloquially to describe that whole set of procedures, which is spread across many sections. So maybe a little sloppy, but anyway, moving on here. So they talk a little bit initially about the purpose of this. So the recognized intent of Section 98 as a whole is to remove or to prevent the acquisition of firearms from those members of the population who have committed offenses or who it may be reasonably anticipated may commit an offense. And they talk about the preemptive prohibition created by Section 98 sub 4 and 6 is in keeping with this purpose. As the results of a review of Canada's gun control legislation indicate, the prohibition can be useful, particularly in reoccurring domestic or neighborhood confrontations. It's actually fairly common that people get this sort of prohibition, not just for domestic confrontations, but people have often talked themselves into a firearms prohibition as a result of ongoing disputes with your neighbors. So if you're a gun owner, don't get into these sort of long-standing petty fights with your neighbors. So they say, while the purpose of the prohibition provisions is clear, the courts have found that the nature of the hearings created is less clear. Disagreement on this point has been the basis for much of the division on the issue of whether hearsay evidence is admissible. And they go through a large number of cases which come to both conclusions. So when you've got a situation like this, where you've got decisions that are going one way in one place and another way in another place, that tends to be when the Supreme Court starts getting interested in a matter and starts saying, maybe we need to step in and sort out the law. So that's pretty much why this case went up to the Supreme Court. And there may be some parallel with the current Section 74 applications that are ongoing, because we've got differing results from differing jurisdictions and differing courts. So that's going to be a bit of an issue going on. So they both tried to refer to other provisions in the criminal code to draw a parallel, and the court didn't really find that useful. They said none of those proceedings is directly analogous to a Section 98 hearing. Therefore, the evidentiary requirements under those provisions cannot be determinative of the issue. So carrying on, they say it enables a peace officer acting on reasonable grounds to apply to the provincial court judge for an order prohibiting a particular person from possessing a firearm. Clearly, the peace officer is not required to act solely on the basis of evidence that would be admissible at a trial. At the hearing of the application pursuant to Section 98 sub 6, the provincial court judge must be satisfied that there are reasonable grounds to believe that it is not desirable in the interests of the safety of the person or of others that the subject of the prohibition application should possess a firearm. The provincial court judge thus confirms the existence of the reasonable grounds which led the peace officer to launch the application. In my opinion, it was not intended that the provincial court judge strictly apply the rules of evidence. The provincial court judge must simply be satisfied that the peace officer had reasonable grounds to believe as he or she did. In other words, that there is an objective basis for the reasonable grounds on which the peace officer acted. It is also relevant to note that the burden which the applicant bears at the hearing is not that of proof beyond a reasonable doubt, but simply proof on the balance of probabilities. So they note that there's a reduced standard in reaching the conclusion. Although these proceedings arise under the criminal code, Parliament did not intend that they be conducted in the manner of a criminal trial. And the court says, I agree with this conclusion. So this second to last paragraph that we're just getting to now is a critical paragraph because there's so much going on in it. And this really could have been expanded into several paragraphs, but they just pack everything in here. So I'm going to try to sort of unpack it as we go, because this is a really big deal. It essentially shapes how firearm prohibitions take place. So they say, accordingly, I'm prepared to hold that hearsay evidence is admissible at a firearm prohibition hearing under Section 98 sub 6, which again would now be Section 111, unless such a result is precluded by the words all relevant evidence. The meaning of all relevant evidence was the principal basis upon which the majority of the Court of Appeal rested its decision. In my opinion, this expression means all facts which are logically probative of the issue. So what does it mean for something to be logically probative of the issue? Well, in this case, the issue is whether or not Mr. Zeolkowski should be banned from having firearms. And so logically probative would be something that makes that more likely or less likely. So in this case, the hearsay evidence about the threats would be probative. It would be something that might, if it's admitted into evidence, make it more likely that the judge is going to impose a prohibition. But there might be other evidence. There might be somebody who comes in and testifies, Mr. Zeolkowski has a reputation as, a safe and responsible gun owner. That testimony about his reputation would also normally be inadmissible, but again, it might be probative under these circumstances. So that would make it less likely for them to impose a firearm prohibition. So that's a very broad admissibility standard. It says that the rules for admissibility are very, very relaxed. The general rule of evidence is that all relevant evidence is admissible. This general rule is subject to certain exceptions, such as the rule against hearsay evidence. Thus, the general rule is that, unless excluded by some rule or principle of law, all that is logically probative is admissible. To state this general proposition more positively, admissibility signifies that the particular fact is relevant and something more, that it has also satisfied all the auxiliary tests and extrinsic policies. So what they're saying here is that normally the base test is relevance. So you can't, at a criminal trial, bring in evidence that is irrelevant. You can't bring in an astrologer, for instance, to start testifying about your star sign, because the court is going to say, well, this doesn't matter. You couldn't testify as to what the contents of your fortune cookie were that morning, again, because it's not going to matter. That sort of thing. So that's the basic rule, is that, we need relevant evidence. However, there's also a number of rules of admissibility that apply, which are normally designed to sort of weed out bad evidence and force people to rely on better evidence. So that's what they're talking about here. That's one of the reasons why hearsay is not normally permitted, is that there's certain problems with it. And if people are interested, I could do a video on hearsay and why the courts don't typically like hearsay, and maybe some of the times when they get to be a little bit okay with hearsay. So continuing on. By using the phrase all relevant evidence, emphasis added, Parliament did not address the question of exclusionary rules. It did not require something more at a firearms prohibition hearing. The effect of the exclusionary rules is left to the provincial court judge as part of the whole body of evidence on which the provincial court judge determines whether he or she is satisfied that the reasonable grounds exist. Frailties in the evidence are a matter of weight. In the case at bar, for example, the judge should properly consider what weight, if any, is to be given to the hearsay evidence. In doing so, the judge should take into account the explanation, if any, for not making the best evidence available. The Crown bears the burden of proof at a Section 98 sub 6 hearing, and I agree with the observation of Judge Killeen in Unterriner, I'm probably mispronouncing that in considering its weight, the judge must scrutinize the evidence to ensure that it is credible and trustworthy. So essentially they're saying, instead of keeping the evidence, evidence that might be a little shaky out with these exclusionary rules, at a firearm hearing, you still, the judge will hear the evidence and consider it, but needs to essentially apply the underlying reasoning for those exclusionary rules in order to determine what weight they should give it. Essentially, how much importance they should give this evidence. And so sometimes, for instance, that weight might be very little. So for example, let's say that you have, somebody's, as with Zeolkowski's, somebody's ex-wife has said, he was making threats against me, and, so that's why I'm scared of him, and that's the basis for bringing the prohibition. Now, it might be that the wife or the ex-wife is not available because, maybe she died of an untimely illness or something along those lines, and she's just not available because, she's not available. But it might be, for instance, that she's not available because she says, I refuse to testify under oath about this. You are not putting me under oath because maybe she's a little worried about perjury. That's a thing. Maybe she's not available because she's in custody in another country for, drug trafficking. And, that might affect her credibility. So the court is supposed to consider those reasons and might say, for instance, this evidence is admissible, but it's still entitled to no weight under the circumstances. Lots of times, so because hearsay is admissible, the Crown on those will almost always proceed using some form of hearsay, often in the form of a police report. But this paragraph also says there's ways to attack the strength of that. And so that becomes very important at a firearm hearing. Continuing on, and then I'll talk a little bit more about sort of the process here. I'm confirmed in this view as to the meaning of all relevant evidence by the use of the identical phrase in section 98 sub 7 and section 104, which requires that the firearms officer consider all information that may reasonably be regarded as relevant to the application. This is a mirror of the Firearms Act application for a PAL, or a possession and acquisition license. So because of this language here, the Supreme Court is saying that this same rule applies to Section 74 hearings where they've rejected your firearms license or revoked your firearms license, that sort of scenario. So they say, clearly the firearms officer must consider information that may not be admissible under the ordinary rules of evidence. It would be incongruous if, having obtained that information, only those parts of it that could meet the test of the rules of evidence could be put before the provincial court judge at the hearing. Giving the same words the same meaning throughout a statute is a basic principle of statutory interpretation. In the present case, the identical phrase is used in two adjacent subsections within the same section of the criminal code. As well, the determinations being made at the one hearing and the other hearing are in essence the same. In both proceedings, the provincial court judge is examining the basis for the decision made by the peace officer or the firearms officer as to whether the respondent should possess or continue to possess a firearm. So they say, accordingly, the appeal is allowed, so the Crown wins, and the matter is remitted to the provincial court judge to be dealt with according to law. So what they're doing here, what the ultimate result is they're kicking this back down to provincial court because the Supreme Court doesn't typically hear facts. That's not their job. They just decide law. So they're saying this goes back to the provincial court judge, and now the provincial court judge is going to have to hear the hearsay evidence and redecide. They're not saying that, Mr. Zeolkowski's getting a firearm prohibition. They're not saying he's not getting a firearms prohibition, but back it has to go. So I don't know what ultimately happened with Mr. Zeolkowski, and it doesn't really matter in the context of this. But this case decided how firearms hearings take place. As I said before, hearsay is regularly tendered in these because they can. However, this is a two-edged sword. This sword cuts both for the chief firearms officer and for the people in court, because those people are also equally entitled to rely on hearsay evidence, which is a really big advantage for people who are essentially self-represented. The reason for that is that self-represented people quite often fail in criminal courts or in civil courts because they get tripped up by admissibility rules. They don't know how to bring their evidence to the court in a way that the court will accept it. However, the all relevant evidence standard essentially forces the court to hear evidence that they might not otherwise, that might otherwise be excluded because you've made some sort of mistake. So this gives you great latitude as to how evidence can be tendered at these. again, hearsay is explicitly admissible because the Supreme Court has said that. That's the decision here. So if you're ever facing a firearm prohibition or needing to challenge or appeal the decision of a chief firearms officer, I recommend that you get a lawyer for the same reason that if you're ever going to be forced into a gunfight, you'd want to have a gun. Your lawyer is there as your representative. They're essentially your weapon in those proceedings. And going in there without one puts you at a disadvantage. However, I also recognize that we still have fundamental access to justice issues and that it can be hard to find the money for a lawyer or to otherwise secure, able counsel. So if you're in the situation where you're having to deal with this on your own, this would be a case you'd want to know and probably a case you'd want to print out and bring with you. You probably won't need it because it's probable that the other side will recognize that hearsay is admissible. But if you're ever getting into an argument about admissibility, this would be the case you'd want to bring out and to show the court. So this is a critical case. As I said before, it's absolutely defined how firearm hearings take place. And yeah, it's essential. This is a must-know case. So thank you for watching. I hope that this has been informative. I hope you've learned something here. I want to thank my Patreon supporters at the $50 level: DMO, People of Canada, Sir Daniel Wicks of Alberta, Canada's National Firearms Association, Toronto Airsoft, and at the $20 level, Cameron Johnson, Kevin Fleet, and Dale Nesbitt, as well as the $10 supporters who will be in the crawl immediately following. Thank you once again. I'm going to include a link to the decision in the description below. And thank you. I hope this has armed you with knowledge.